Hello and welcome to the class. Today we will discuss about the evolution of European concept of human rights. Introduction. Man is a social being and cannot live outside society. The problem of rights arose involving man's relations with other individuals in a society and his relations with state government. Thereby, man implicitly or explicitly evolved certain norms of social behavior which got crystallized over centuries' struggles. Such norms have turned to be human rights in due course of time. The European Convention for the Protection of Human Rights and Fundamental Freedoms was the first comprehensive treaty in the field of international human rights. It established first international complaint procedure and the first international court for the determination of human rights matter. It remains the most judicially developed of all the human rights system. Now, let us talk about the Council of Europe. In the aftermath of World War II, European states formed the Europe with the aim to achieve a greater unity for the purpose of safeguard and realizing ideals and principles which are their common heritage and facilitating their economic and social progress. Integral to the Council's aims was the formulation of the European Convention for the Protection of Human Rights, that is ECHR, to protect the right of citizens of Europe and to ensure that the human rights abuses committed in World War II were not repeated. Today, the ECHR has 47 signatories and provide constantly evolving human rights protection to over 800 million people. The Council has further extended human rights protection with the creation of other treaties, including the European Social Charter, the European Convention for the Prevention of Torture and other cruel, inhuman or degrading treatment or punishment, and the Framework Convention for the Protection of National Minorities. Now let us talk about the European Convention on Human Rights. The ECHR came into force in September 1953 and represents the minimum human rights protection a state party must guarantee to its citizens. Rights under the Convention can be absolute, derogable, or qualified. States may never derogate from obligation, uphold absolute rights. Absolute rights include the right to life under Article 2, the prohibition of torture, that is Article 3, prohibition of slavery, Article 4, Clause 1, and the prohibition of punishment without law, that is Article 7. Other articles in the Convention may be derogated from in some circumstances, provided that this is not inconsistent with other obligation under international law. Article 15 allows all non-absolute convention rights to be derogated in the time of war or other public emergency threatening the life of the nation. Derogable rights may also be expressly qualified in the Convention. Rights containing express limitation are termed qualified and include the right to respect for private and family life, that is Article 8. Freedom of thought, conscience and religion, that is Article 9, and freedom of expression, that is Article 10. a state may only limit qualified rights if the qualifications imposed are prescribed by law and are necessary in a democratic society. Limitations must also be proportionate to the legitimate aim pursued. Legitimate aims include interest of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation of rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. 6 subsequent protocols have further expanded the substantive protection offered by the ECHR. To come into force, protocols containing substantive rights must be ratified by a minimum number of states as specified in the protocols. Protocols alerting procedure enter into force only when ratified by all contracting states. However, applications alleging violation of rights contained in the protocols can only be brought against states that have ratified them. The rights contained in the ECHR are the main civil and political rights. Most of the rights protected offer security to the individual, with few rights pertaining to groups. This is exemplified by the lack of protection granted to minority groups as groups under the Convention. However, individuals' rights as freedom of assembly and association do enhance the protection of group to some extent. Most of the rights included in the ECHR can be found in other international and regional human rights law treaties, including the International Covenant on Civil and Political Rights, that is ICCPR. However, the absolute prohibition of the death penalty contained in Protocol number 13 is unique to the Convention. The preamble to the European Convention refers to the European countries which are like-minded and have a common heritage of political tradition, ideals, freedom, and the rule of law. The other points which describe the European Convention is known as genuine democracy of the effective political democracy. The preamble constitutes only the first steps for the collective enforcement of certain rights stated in the Universal Declaration. The European Convention was signed in Rome on 4th November 1950 and entered into force on 3rd September 1953. A central feature of this regime is the right of individual and interstate petition, and at the request of the Committee of Ministers, the European Court of Human Rights may also give advisory opinions on the interpretation of the Convention and the protocols. The role of the Court and the Committee of Ministers are that of review and not that of an appeal court from the decision of national tribunals. Their task is to ensure that the standard of the Convention and its protocol are observed by the administration of the state concerned. The work of this institution has had important consequences. Valuable material has been provided for the elaboration of the provision of the civil liberties, and anomalies have been exposed to national systems of law, often with the result that the relevant national legislation has been changed for the better. Now let us talk about the rights recognized in the ECHR. The European Convention adopted various provisions relating to the rights and freedoms secured to every high contracting parties to the Convention. First section of the Convention prescribes rights and freedoms such as right to life, that is Article 2, prohibition of torture, that is Article 3, prohibition of slavery and forced labor, that is Article 4, right to liberty and security, that is Article 5, right to fair trial, Article 6, right to respect for private and family life, that is Article 8, freedom of thought, conscience and religion, Article 9, freedom of expression, that is Article 10, freedom of assembly and association, that is Article 11, right to marry, that is Article 12, right to effective remedy, that is Article 13, prohibition of discrimination, that is Article 14, prohibition of abuse of rights, that is Article 17. By May 2012, all 47 member states of the Council of Europe were parties to the European Convention and protocols. Following the entry into force of Protocol number 2 on 1st November 1998, the control machinery was substantially restructured. All alleged violations of human rights are referred directly to the court. In most cases, the court thereafter sit in chambers of 7 judges, decided on the admissibility and merits of applications and, if necessary, undertook an investigation. The court also made it available to the parties with a view to securing a friendly settlement on the basis of human rights as defined in the Convention and protocols. Coming to European Court and its procedure. The European Convention provides establishment of European Court of Human Rights under Article 19. It provides for both individual petition, that is Article 34, and interstate complaints, that is Article 33. The individual petition brought by individuals, legal persons such as corporation, groups of individuals or NGOs have grown exponentially in numerical terms. The Convention makes clear that the primary responsibility for implementation rests with the member states themselves. The implementation machinery of the Convention comes into play only after domestic remedies are considered to have been exhausted. The great majority of complaints submitted are deemed inadmissible, frequently on the ground that domestic law provides an effective remedy for any violation that may have taken place. The obligation of member states under Articles 1 and 13 of the Convention to secure to everyone the Convention's rights and to provide an effective remedy before a national authority for violation of those rights. The remedy given by a domestic court may be in pursuant of provisions of domestic law that stand relatively independent of the Convention, although perhaps influenced by it. Such a Human Rights Act, a Code of Criminal Procedure, or a constitutional procedure into domestic law. In terms of institution, all complaints were first considered by the European Commission on Human Rights. It initially considered whether a complaint was admissible. If it was, an effort was made to break a friendly settlement as provided for the Convention. In the absence of such a settlement, the Commission reported on the facts and expressed its opinion on the merits of the case. That report went to the Committee of the Ministers, a political body which could endorse or reject it. For instance, whether states concerned have opted to accept the compulsory jurisdiction of the court, either the Commission or the state could refer the case to the court for a final, binding adjudication, including whether it is appropriate and an award for the compensation. The court was thus dependent on the Commission or the state concerned in order to be able to consider a case. A major reform introduced in 1994, when Protocol number 9 entered into force, allowed applications to submit their case to screening panel composed of 3 judges, which decided whether the court should take up the case. Now let us talk about the interstate procedure. Article 33 of the revised convention contains a procedure by one or more states may allege breaches of the convention by another state party. This procedure has generally been used very sparingly. In relation to the member state of the European Union, this sparingly used procedure is likely to be reinforced by Article 7 of the European Union Treaty. The European Court's interstate procedure will continue to be the only option in relation to disputes between non-European Union member states. Between 1956 and 1999, the former Commission considered 17 interstate applications. Now coming to the court's jurisdiction. The European Court cannot consider an application unless it ascertains that it has jurisdiction over the case. If an event occurred prior to the state becomes a party to the European Court and has no continuing dimension, or if the state whose conduct is complained about is not a party to the convention, and so on, the court will have no jurisdiction. The issue of extraterritorial jurisdiction arises in connection with situations which have become increasingly common. For example, situations in which a military strike is launched from within the legal space of the Council of Europe but results in damage outside that area. Actions taken by armed forces of one state operating in the territory of another, which may or may not be a member of the Council of Europe, and the responsibility of a state contributing troops to UN or other multilateral peacekeeping force under the UN Security Council. After all the discussions we had, we can conclude that the European Convention for Protection of Human Rights and Fundamental Freedoms is the first important regional convention on human rights, which goes beyond the Universal Declaration of Human Rights and gives effect to civil and political rights contained therein by binding commitments. It precisely defines civil and political rights and clarifies the contents of these rights by aiding exceptions, limitations, or restrictions to which such rights are subjected. It provides machinery for the implementation of rights, namely Commission, the Court, and the Committee of Ministers. European human rights guarantee were driven by an ambition to put in place a collective pact to prevent the re-emergence of totalitarianism in free Europe. They were motivated by grisly memories of human rights abuse associated with World War II, and the protection of human rights was seen in that light. Thank you.